welcome to Crime in Court. My name is Heather, and this is episode 77 of the Canton Cover Up Commonwealth versus Karen Reed. And we also talk about Turtle Boy on this channel. But today we're going to be reading through the civil suit or through some motions that Karen Reed's team just filed. And so, as you can see from the title, it is Karen Reed files motion to stay the O'Keefe's civil suit. So, what does that mean? Basically, they just want to wait for litigating this until after the jury trial concludes. So we're going to read a bunch of filings and then we're going to actually read the O'Keefe's response to them too. So let's get started. Please hit that like button and let's begin. All right, so this is Paul O'Keefe as personal representative. Paul is John O'Keefe's brother. He's the personal representative of the estate of John Joseph O'Keefe the third. Okay, he was a third. I didn't realize that. Paul O'Keefe individually. So Paul is suing on behalf of his brother. On behalf of himself, he's also suing or or Peggy O'Keefe as the grandparent or guardian of. Oh, so so let me get this straight. Okay, so it's Paul O'Keefe as the representative of John, and then it's Paul O'Keefe as himself. Then we've got Peggy O'Keefe. Oh, John O'Keefe the second, so the senior, John O'Keefe Sr. And then we've got Peggy as the grandparents, guardian of Kaylee Furbush, who is the niece. So that's like five people, five individuals, I guess, that are collaborating in this lawsuit. Hold on one sec. So yeah, if you count all the on behalf ofs and everything, that's like five people suing C&C Hospitality LLC, which is doing business as CF McCarthy. So that's one of the bars that John was out at that night with Karen. Then you've got G&S Hospitality LLC DBA for also CF McCarthy's. Then you have Waterfall Bar and Grill Ltd DBA, just doing business as Waterfall Bar and Grill, and Karen Reed. So they're suing the Waterfall Bar and CF McCarthy's and Karen. So this is going to be a huge mess. Let me shrink myself so you guys can see. All right, so here we go. Now that we got all the individual parties down. All right, so this is the first filing request for a hearing pursuant to Superior Court Rule 9AC2. Defendant Karen Reed, per her counsel, respectfully requests a hearing on her motion to stay civil proceedings pending resolution of criminal trial. So you can see what her motion is about. She wants to put a stop to this, like a pause. Put the pause button on this lawsuit, this civil suit, until the criminal trial. All right, so what is the motion? Let's read the motion, and then we have a memorandum in support of motion. So we're going to read both. All right, so here is defendant Karen Reed's motion to stay civil proceedings pending resolution of criminal trial. A defendant, Karen Reed, respectfully requests a stay of this civil action until conclusion of the pending criminal trial in Norfolk Superior Court. Criminal trial involves the same circumstances alleged in the civil matter and is scheduled to begin on January 27th, 2025. A stay is appropriate here, where proceeding with the civil action at the same time as the criminal action will adversely affect Ms. Reed's Fifth Amendment rights and her ability to vigorously defend herself from criminal prosecution. The requested stay involves minimal delay and is not prejudicial, as the civil tracking order contemplates on August 2026 discovery deadline. Uh, okay, so they're asking for an August 2026 deadline, and we filed. I don't know. I don't. I don't understand why they did this. And August 2027 dates for depositions. Massachusetts law indicates that a stay is appropriate in such circumstances. In the event of parallel criminal and civil cases, the civil action often will at least partially be stayed until the criminal case has concluded. Pursuant to Superior Court Rule 9A, a supporting memorandum is filed together herewith. that's, that's a fun word. A hearing is respectfully requested. And oh, by the way, hold on one second. Let me pull something up. All right. So I pulled up very quickly the Karen Reed is innocent X page has posted images of each of the new attorneys on the Karen Reed civil suit. So this is Christopher D. George. Oh, whoops. Yeah, there we go. That's bigger. William L. Cavill Jr. There's more information about them, like their bios and stuff, but I wasn't going to read through all of that. You guys are welcome to on your own. So these are some good attorneys that she has brought on. So, and also Marissa Palladini. So, Christopher, William, and Marissa. So, welcome to the Karen Reed defense team. Those are the new individuals that are going to be defending her in the civil suit. She still has Alan Jackson and David Yannetti plus Liza Little. So her original team, nobody's left. Um, so her original team is still on for the Karen Reed trial. For the civil suit against the O'Keefes, this is her new team. And then she also has added Weinberg, what's his face? I can't remember his first name, Weinberg, to her team, who is doing a lot of the appeal work. So, get my hair sticking to my face. I'm sorry. Okay, annoying me. All right, so that's the new team. And this was written by William Cavill Jr. These are her new defense attorneys. So that was the motion to stay. Here is the memo in support of motion to stay. The defendant, Karen Reed, respectfully requests a stay of this civil action until conclusion of the pending criminal trial in Norfolk Superior Court, which is scheduled to begin on January 27, 2025. On balance of the parties' competing interests, the relevant factors, and Ms. Reed's Fifth Amendment privilege, a stay is both warranted and essential here. Legal standard. The decision to stay a civil action pending the outcome of criminal proceedings is in the direction of the presiding judge. In considering a request for a stay, it would constitute a clear abuse of discretion for the judge to turn a deaf ear to a serious claim of privilege. The privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is ongoing. Given the discretionary nature of the court's role in ruling on a motion to stay, the decision to grant a stay ultimately requires and must rest upon a particularized inquiry into the circumstances of and the competing interests of the case. This inquiry involves a balance of the prejudice to the other parties against the harm to Ms. Reed should she be compelled to choose between defending the civil action and protecting herself from criminal prosecution. So she would have to make a huge decision. Do I speak up? And, in this case, or do I plead the fifth and risk losing the civil suit? So, and if she does speak, during the civil suit. If it had happened before the trial, then anything that she says in the civil suit can be used against her in the trial for John O'Keefe's homicide. So not really in her interest. I mean, it puts her in a really bad predicament. So I would think that they have to stay it. The inquiry on a motion to stay involves consideration of other competing factors as well, which Massachusetts courts have derived from federal courts. Such competing interests include, amongst others, 1. Interests of non-parties, 2. Public interest, 3. Overlap of the issues, 4. Procedural status of the criminal case, and 5. Interests of judicial economy. All right, the argument. A balance of the potential burden and prejudicial effects weigh in favor of a stay. There will be no prejudice to the plaintiffs nor to the co-defendants should this brief stay be granted. To the contrary, Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should this civil litigation proceed while her criminal trial takes place. The only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. The inconvenience does not outweigh the importance and interest in the protection of a defendant's constitutional rights. Moreover, the court's tracking order allows for discovery up to and including August 17th, 2026, and sets so the court tracking order allows for discovery. Okay, so up man, why does this need to be litigated right now? Because they're not even asking for discovery until August 17, 2026. So, I don't know. And sets forth a final disposition date of August 26, 2027. So, strange. The parties will have ample time to fully discover the facts concerning the allegations and offenses raised in this civil matter upon conclusion of the criminal trial presently scheduled for January. On the other hand, without a stay, Ms. Reed will be forced to decide between exposing herself to a procedural default or waiving her Fifth Amendment rights. Ms. Reed is not merely under criminal investigation, she has been indicted, mistried, and now awaits a second trial. The basic filing of a responsive pleading to the complaint alone could compromise Ms. Reed's defense against criminal prosecution. The defendant has now been indicted, so exposure to criminal liability cannot be considered a possibility. It is a reality. The potential burden and harm to Ms. Reed significantly outweighs the insignificance to the other parties of a time delay. Thus, on balance, these factors favor a stay. So there's no real reason to rush this before the trial. And a time delay isn't going to hurt them, you know? I mean, the civil suit can be adjudicated later. It's not going anywhere. B. Public interest and the interests of non-party witnesses favor a stay. The public and non-party interests surrounding this case weigh in favor of a stay. There is a significant public interest in providing criminal defendants with a fair trial and protecting their constitutional rights, while the public interest is also served by providing plaintiffs and defendants an efficient forum to resolve civil matters. This civil action can still be fairly litigated within the time frame set forth in the attached tracking order despite a stay. The public interest therefore favors a stay of the civil case. Again, there's no rush and the deadlines are so far out. Why are we doing this now? Can we just wait? There's no reason for us to put our client in danger of potentially saying something that might incriminate her. Not that she did anything, I don't believe she did anything incriminating, but the Commonwealth will use anything she says against her. So it's just better for her not to talk. Non-party witnesses will similarly benefit from a stay. It is anticipated that many witnesses will testify at the upcoming criminal trial. So are there witnesses? Maybe well, we know Paul O'Keefe was a witness. John O'Keefe Sr. was a witness on the defense list. Strange. But they never called him because they only called 6 witnesses and then they skedaddled out of there, hoping that, they had won the case because they were so ahead. And it appears they needed to do a little bit more, I guess, fleshing out some things. But they can figure that out for the next trial because hopefully she's only charged for manslaughter if we hear something from the SJC soon. Maybe they can get Bev to ask all 12 jurors what their verdict was for counts 1 and 2, or counts 1 and 3, sorry, because we know that those are the counts that there is a discrepancy in what people are saying and what actually happened. All right, continuing on, non-party witnesses will similarly benefit. It's anticipated that many witnesses will testify. Like I was saying, John O'Keefe Sr., those 2 were witnesses, but I wonder if there are individuals. We know somebody testified from, I believe, C.F. McCarthy's, not the waterfall, but I can't remember which. Somebody testified from one of them. And so now they're gonna be witnesses potentially at this upcoming trial as well, because maybe they can say, yeah, Karen wasn't drunk. Everybody said it. Everybody that was there said she wasn't drunk, didn't appear drunk. But yet somehow she got drunk on the way there, which was like a 10-minute drive. The same witness's testimony may also be relevant to the parties' arguments and defenses in the civil litigation. If the litigation proceeds and overlaps with a criminal trial, these witnesses could conceivably be subjected to testifying on the witness stand while simultaneously being called for deposition in civil discovery. This would place an unfair burden on both the witnesses and the parties in both the civil and criminal litigation. Thus, this factor also favors a stay of the civil case. C. The overlap with the criminal case and procedural status of both cases further warrants a stay of the civil proceedings. The allegations and issues in the criminal case directly overlap with the issues in the civil case. The decedent, witnesses, and evidence are the same in both cases. So, yeah. Ms. Reed's second criminal trial is scheduled to begin on January 27th, 2025. How many times do they tell us that? They don't want us to forget. A trial date has been assigned, and the Norfolk Superior Court will reach the criminal trial years in advance of the trial of this civil action. The tracking order for this civil action provides the parties with 2 years' time for discovery and 3 years' time for the final disposition. Even with a stay, the parties will still be on track to complete discovery within the current deadlines. Thus, the overlapping issues and procedural status of the 2 cases also favor a stay. D. The civil action should be stayed in the interests of judicial economy. Ms. Reed's proposed stay serves the interest of judicial economy. The stay will alleviate the court's burden of ruling on potential discovery motions and requests for protective orders should Ms. Reed decide to invoke her Fifth Amendment privilege. Maybe she would. It is in the best interests of this court, the parties, non-party witnesses, and the public to allow this brief stay until Ms. Reed's criminal trial concludes. Thus, judicial economy also favors a stay of the civil case. Conclusion: the competing interests and relevant factors all weigh strongly in support of a stay of this civil action pending completion of Ms. Reed's criminal trial. In light of the foregoing, the defendant, Karen Reed respectfully requests a stay of all proceedings in the above captioned matter until conclusion of her upcoming criminal trial in Norfolk Superior Court, which is presently scheduled to begin on January 27th. So she can, if they stay the case and she goes through trial, well, first of all, let's say that they do drop the two charges and she's only up for manslaughter. Or let's say they don't. And she's and she still goes up for all three charges again: manslaughter, homicide in the second degree, and driving away from an injury or someone who lost their life. So those are her three charges, which we know she was acquitted on two of them, but the Commonwealth says no. So um, in response to that, let's just say that all three charges she's up against again, and she gets acquitted of all three charges. She gets a not guilty on all three next time. Then Paul has no say in, well, not that he has no say. He still could do the civil suit. He could still sue her, but it doesn't, there's a lot, it wouldn't be as strong of a case if you come back and say, well, actually, Your Honor, she was found not guilty on all three charges. And you can really fight a civil suit once you have that resolution, because otherwise, what's the point? And then you've got will she's also waiting for oral arguments to be heard with the SJC regarding those two charges. So in that case, again, like, wouldn't you want that resolved and to know whether you are going up against all of those charges or not? And if you do get acquitted of those two charges right up front, if Bev does have to call all the jurors back in, ask them for a verdict, and then get one, and everybody says, yeah, we acquitted her, because that's what I expect everyone to say. Six individual jurors have said it through an intermediary or directly to Karen's defense team and the Commonwealth. A combination of all of those. At least six people have reached out, and Turtle Boy. One of them reached out to Turtle Boy and got an interview. So yeah, six people have said that she's acquitted. So wouldn't you want to know? Wouldn't Paul O'Keefe want to know if she's acquitted or not before all this goes to trial, if it does? Because I imagine she's going to fight it really hard, and if it means going to trial, she's going to go to trial for it because she didn't do anything. All right, so here is Paul O'Keefe. Let's make this bigger. Here's Paul O'Keefe's response, or the O'Keefe's response to her motion to stay. In the instant motion, civil defendant Karen Reed seeks to stay civil discovery largely because Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should the civil litigation proceed while her criminal trial takes place. Sorry, my dog just keeps making a lot of noise. I gotta cut his nails. But that doesn't even help because he drags his nails like I drag my feet when I walk. So it's like, dogs and owners start to do things the same. He drags his nails on the floor and makes so much noise. Anyways, so I don't know where I was or what I was saying. Oh, I read this sentence. So Ms. Reed's ability, okay, he says so simply because Ms. Reed does, she's not going to be able to defend herself in a criminal prosecution. That's not a reason. I think that's a huge reason not to continue with this, or at least that's a huge reason to ask for a stay. She needs to defend herself from going to prison for the rest of her life. And Paul O'Keefe doesn't get it. Paul O'Keefe is not that bright. I don't think any, well, I don't know. I'll stay quiet. Paul O'Keefe and his family sat through the same trial that we watched, and yet they still believe Karen did it. So I don't know. I believe in supporting the victims, and they are victims. But when your rational thinking and your common sense go out the window because you're a victim, I don't have a whole lot of pity for you. I just don't. And to say, well, we should we shouldn't do this just because she can't defend herself. Well, that's a huge reason why we shouldn't do this, and that alone should be reason enough because she can't defend herself in a criminal prosecution this way. Anyways, sorry. That just really made me mad thinking that because that's exactly what they're saying. Let me go back and restart the sentence because we got interrupted. So, in the instant motion, civil defendant Karen Reed seeks to stay civil discovery largely. So, basically, they want to stay so that they don't have to give over discovery, which is going to hurt her with the defense, obviously. So, she shouldn't be just giving it over. Sorry, I'm going to start over again. I do this, my brain. In the instant motion, civil defendant Karen Reed seeks to stay civil discovery largely because Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should this civil litigation proceed while her criminal trial takes place, and because the privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is ongoing. Again, another huge point as to why it should be stayed. The 2 points that they're saying don't matter are what would make a stay necessary. Additionally, Ms. Reed claims the only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. In certain cases, we may agree. Here, however, Ms. Reed consistently and voluntarily disregards her Fifth Amendment privilege as she attempts to craft her own narrative and poison the jury pool. Ooh, Karen Reed is so evil and diabolical. She's poisoning the jury pool with the truth, guys. She's poisoning them all with the truth in both the criminal and civil cases. Ms. Reed has spoken publicly in interviews that we know of with NBC's Dateline, ABC's Nightline, ABC's 2020 Vanity Fair, NBC's Today, and yet to be disclosed Netflix documentary. In light of her open willingness to speak publicly, Ms. Reed's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self incrimination and more about controlling the narrative to suit her interests. Oh my God, this guy. Um, Moving on. The court, in its discretion, certainly should not reward her ulterior motive of self promotion. The right not to self incriminate does not come with the right of self promotion. Legal standard. The movement carries the heavy burden of establishing that a stay is warranted. I think she did, and that's why she's asking for a hearing. It is well settled that the Fifth Amendment privilege against self incrimination applies alike to civil and criminal cases. Okay? Testimony given in a civil deposition does not waive Fifth Amendment privilege for purposes of substantial criminal trial. Um, but anything she says in a deposition can be used in the criminal trial. So they don't want her speaking for, like a documentary or Vanity Fair or whatever. Speaking to the media is not the same as testifying under oath or not choosing not to speak under oath. It's not the same, but that's what they're trying to equate it to. Testimony given in a civil deposition does not waive Fifth Amendment privilege. Okay, nevertheless, there is no constitutional requirement that a civil proceeding must yield to a criminal one, even in the presence of a defendant's perceived need to assert the Fifth Amendment privilege. The United States Constitution rarely, if ever, requires a stay of civil proceedings pending the outcome of criminal trial. Rather, the decision to grant such a stay rests on the ground discretion of the presiding judge, requiring a particularized inquiry into the circumstances of and the competing interests of the case. Courts must weigh any prejudice to the civil litigants which might result from granting a stay against the potential harm to the party claiming the privilege. The rights of the party to the civil action are to be considered an equal. Justice is melted out in both civil and criminal litigation. The overall interest of the courts that justice be done may very well require that the compensation and remedy due a civil plaintiff should not be delayed. Okay, but you're taking things out of context and just throwing it in there. And her right to remain silent and not speak under oath or take the stand is still very much in play as she's going to be retried. Summary of facts and procedure. A simplified summary of facts introduced at a criminal trial and the procedural history is as follows. Defendant Karen Reed consumed 9. That is not fact. And there's no proof of that. She did not. I call false. She did not drink 9 drinks. We know she ordered some. She ordered drinks for everyone that she was with, for other people in the group. She went to 2 separate bars. The one tab that we did see, that the one bartender came to testify to, was like 30 something dollars. So that doesn't even come close to 9 drinks. And that was for her and John. And then um we never saw a bill for the waterfall. We don't know how many drinks she took there. We saw her, I think, do a shot, and maybe she had like some seltzer water or something, and she was pouring other shots in them. But you can't, that doesn't equal 9 drinks. And where he got 9 drinks, that was all from Sergeant Buchanan, who was on the stand and totally providing a narrative during the surveillance video of Karen Reed and John O'Keefe at the waterfall bar. And that's when he said something like, "Oh, she just had 7 drinks." And I'm watching the same video and I'm like, where? Where is that? Like he was counting them. I'm like, I don't see the drinks that he's counting, but okay. Moving on. Defendant Karen Reed consumed 9 alcoholic drinks over approximately 3 hours at 2 Canton bars. Reed and her boyfriend, John J. O'Keefe, left the waterfall bar and Reed proceeded to drive drunk. Again, that is not fact. We do not know that. They're calling this summary of facts, by the way. It is not fact. These things were highly disputed at trial. She transported O'Keefe from the bar to a house party in Canton. That she did. That she did. After dropping off O'Keefe, Reed backed up her Lexus and struck O'Keefe, who was knocked down and left to die in blizzard-like conditions. The lengthy criminal trial ended in a mistrial. In an affidavit filed by defendant's own criminal counsel in Norfolk, 8 of the deliberating jurors favored conviction on the same counts that overlapped the plaintiff's claims in the civil matter. That was on manslaughter with no intent, and Paul O'Keefe's civil suit is claiming that she maliciously intended to take John's life with her car. And they acquitted her on homicide, which has intent. So good luck, buddy. Good luck. They forgot to add that part. Plaintiffs filed the instant action on or about August 26th. Argument. The estate has great reason to pursue civil justice against Karen Reed for wrongful death, whereas 8 out of 12 jurors Uninfluenced by the media circus, I call bull. I call somebody influenced that jury. When tasked with resolving the facts under the higher standard of proof beyond a reasonable doubt, believed that Reed was guilty of OUI manslaughter. Our civil case only requires 5 out of 6 of the jurors, when tasked with resolving the facts under the lesser standard of proof, more probable than not, to hold Reed liable. Yes, but they don't have all of the evidence that we have on the McAlberts that's going to come into discovery for this if somebody brings them onto the lawsuit, which that would be really, really smart. If CF McCarthy's, the Waterfall, or Karen wanted to add the McAlberts to this lawsuit, they could. They could say that those are also parties that were in attendance at the bars. So they too could be negligent in some way to let John get in a car with Karen Reed if she was so drunk. Anyways, any two of those criminal jurors who maintained no there would easily have been persuaded to change to a yes in a civil case here. Well, that's your opinion, and that's not with all the discovery. So, and it wasn't even the uh, where's he getting two? Any two? Oh, I don't know for his math. It is not difficult to imagine two of the no jurors being persuaded by the deliberating jury that Reed's drunk driving more likely than not caused O'Keefe's wrongful death. Anyone familiar with the O.J. Simpson cases understands that there can be disparate outcomes with similar sets of facts, not only because the civil standard is lower, but also now the jury gets to assess the credibility of the alleged wrongdoer. Dun, dun, dun. How about we look at the McAlberts instead? Plaintiffs here are entitled to civil discovery, including the under oath testimony of defendant Reed, not only to hear her version of events, but also to assess her credibility. Plaintiffs noticed Reed's deposition for December 5th, 2024. Despite her contention that proceeding with civil discovery would compromise her defense in the criminal prosecution, Reed has repeatedly emphasized that she wants to talk and is eager to provide her account of the events in question. Yes, but she needs to do that. It's like she can say that she wants to do that, but she needs to say it at the right time. She doesn't need to do it on Paul O'Keefe's terms. She wants to do it on her terms when she tells her truth, not on Paul O'Keefe's. Indeed, she has addressed the matters publicly on several occasions, making her own narrative a prominent part of the public discourse. She is a victim of the justice system, so it is a big part of the discourse. Moreover, there is no shortage of reporters, bloggers, and persons claiming that Reed is actively speaking about the facts. This public engagement raises troubling questions about Reed's true intentions. If Reed genuinely has concerns about her statements being used against her, it seems contradictory. She would continue to speak out. She would continue to speak out so openly. By actively participating in public discourse and potentially profiting from media engagements, Reed effectively foregoes any claim of Fifth Amendment protection. They hate her. Like, they despise that she is not sitting down and taking this. They cannot stand that she is claiming innocent. And that's what this is about. They despise her 100%. And they don't want her to, like, they think she's smug, they think she's getting away with something and flaunting it around by going to the media and whatnot. She has every right to do that. Every right. That doesn't mean she's waiving her Fifth Amendment right. Karen Reed, Karen Reed's choice to speak out starkly contradicts any suggestion that she is concerned with self-incrimination. Now Reed comes here asking this court to allow her to have it both ways. Furthermore, the O'Keefe family has compelling reasons to pursue their claims with urgency As there are legitimate questions in this case regarding witness and jury manipulation. Yeah, there are. There are, but it's with the McAlberts. So let's be clear here. The people manipulating witnesses and jurors are the McAlberts. There was someone who I watched a video on TikTok. She didn't even pass by D&E Pizza. Like she went out of her way. She made it a point to go out of her way. She went to CF McCarthy's to meet up with some people, and she parked way across the street, went out of her way all the way to the crosswalk and walked around so that she didn't have to walk in front of D&E Pizza. Well, apparently Chris Albert, who owns D&E Pizza, he still saw that she had a Free Karen Reed sign on her car from far away across the street. He surveils the parking lot and the street around his business to find people that support Karen Reed and calls in license plates and tries to get these people in trouble. He has, well, the point of the story is that after, so she left. She did the same thing. She didn't walk past CF McCarthy. She went back around all the way, went to her car, which was parked far away from D&E. And yet, after that, she had people following her, like legit following her to work, home, like everywhere she was going. And that happened right after going to the CF McCarthy's thing. And somebody told her, like, oh, he probably saw that you had a free Karen Reed thing in your car. So don't tell me that the McAlberts are not capable of manipulating or somehow intimidating a jury. They were there during closing arguments to do that same thing, to intimidate the jury. Anyways, all right, so further delay not only affects witnesses and jurors, but also the O'Keefe family, who have been dealing with a loss since January 29th, 2022. The first criminal trial extended beyond a full calendar month, and the second trial is not set to begin until more than 4 months from now. Furthermore, there is no assurance that additional delays, another mistrial, a lengthy appeal, or other legal complications will not arise, extending Reed's authority to postpone the civil proceedings. If she chooses to plead the fifth in the civil proceeding, she may do so with consequence. However, if she wants to speak under oath as freely as she does for the media and others, plaintiff welcomes the opportunity to obtain her testimony. Fuck you. Wow, sorry, that really was so condescending. By allowing the civil case to proceed, the court demonstrates a commitment to transparency and the timely resolution of such various matters, which is crucial to maintaining public trust in the legal system. A stay would only delay justice and would foster frustration among the public who are closely watching both proceedings and expect the court to take decisive action. The public's confidence in the legal process depends on seeing justice served in a prompt and effective manner. Denying the stay ensures both the civil and criminal matters are addressed on their own merits without unnecessary postponement that could undermine public faith in court's ability to handle such a high profile and sensitive case. I'm sorry, buddy, your civil suit isn't quite as high profile. Get over yourself, Paul O'Keefe. It's a civil suit. It's probably not going to be aired on TV, but okay, you can think what you want. Maybe it will, maybe because media is basically controlled by the government, so maybe it will. I don't know. Maybe they want it aired too. Anyways, so conclusion. While Karen Reed argues that civil discovery should be stayed to protect her Fifth Amendment rights, her actions say otherwise. By openly discussing the case in various media outlets, Reed demonstrates a clear intention to influence public perception and poison the jury pool in both her civil and criminal cases. This selective invocation of her rights undermines the very protections she seeks and raises serious questions about her motives. Under the circumstances, it is reasonable to proceed with civil discovery, allowing both parties to pursue their interests while ensuring that the judicial system process remains fair and balanced. Somebody named Mark Diller from the Diller Law offices. So that is, ugh, Paul is icky. Like, he just gives me that icky feeling. And I feel like this is just because his cash cow, his niece and nephew, have run out. He started a GoFundMe page. Let's talk. So he started a GoFundMe page after the parents of his niece and nephew died. The kids never got that money, allegedly. Allegedly, Paul O'Keefe used it, bought himself some things. I don't know, maybe a car and whatnot, some things that might be expensive. He might have maybe somehow allegedly taken all of the GoFundMe money that he raised for his niece and nephew when their parents died. So you tell me, is he after this for justice? Is he after money? What is he after? What is he really truly after? If he wants the truth, let it play out in the courts again. In a court where it's not so lopsided and you've got a corrupt prosecutor and a corrupt judge trying to lean one way and making verdicts of not guilty disappear. So these are some things that are seriously wrong with this case. Yet we're going to sit here and say, well, she talked to some media sources, so she can't keep her Fifth Amendment rights. Baloney is what I say. I think this is Paul O'Keefe's next dollar sign that he sees. All he sees with Karen Reed are dollar signs. And that is my opinion. I don't care if you don't like it. I'm sorry if you don't. That is just where I'm coming from. I've been covering this case long enough. Some people were like, well, you make a lot of allegations and blah, 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 blah. I speculate. There is room for speculation in this case. I do speculate in this channel, and that's not going to stop. Um, but I have also been following this case for over a year and a half, and I'm very well aware of what's going on in this case and how things are looking. And I've looked through all of it on this channel and more. So, just trust me when I make some speculations. I think, maybe I am speculating on things that I kind of know a thing or two about. Just saying. That's all I'll say about that. So, anyways, thank you guys so much for watching. I hope you enjoyed. And I've got more stuff a coming because this is a case that just doesn't stop. We're going to have more things, more episodes coming in the future on this that I already have planned. So please hit that like button. Make sure you are subscribed so you don't miss out. And I will see you guys in the next one. Take care. Bye now.